Hello and welcome in this presentation. I will provide concise legal advice for two different case studies using the IREC method, that's issue, rule, application, and conclusion. We will begin with the dispute between Jackson and Omniword before turning to second case study, that's Alicia breaches of director duties. The central issue here in the first case study is very simple. Can Omi Word rely on the exclusion clause in the document Jackson signed to avoid liability for his injury? The outcome depends on whether that clause was validly incorporated into the contract. The legal rules come from both case law and statute. First, if we will see in the case law under L. Strand versus Broncorp, a signed contract is usually binding, even if unread. But there's an exception. If the signature was obtained by misrepresentation, as happened in the Curtis versus chemical cleaning, the term is not binding. Importantly, Section 64 of the Australian Consumer Law makes any clause that try to exclude liability for personal injury caused by negligence absolutely void in consumer service contract. These statutory rules alone is decisive. Let's apply these rules. The document was misleading labeled to boost our marketing. Sorry, to boost our marketing, disguising its real purpose. This mirrors the misrepresentation in Curtis versus Cleaning. Jackson was also pressured to sign without reading, making the clause unenforceable at common law. On top of that, go-karting clearly qualifies as a consumer service under the ACL, Australian Consumer Law, so the clause is void regardless. Omniword losses on both legal and statutory grounds. In conclusion, Omniword cannot rely on the exclusion clause. Jackson has strong grounds to sue in negligence. Omniword's only remaining defense is contributory negligence, arguing Jackson was partly to blame. Even then, it would merely reduce damages rather than remove liability altogether. Next, case study two. Now turning now to the Alicia's key question is which specific director duties has Alicia breached? So the Corporation Act outlined these duties clearly. Section 181, act in good faith for the company's benefit. Section 182, never misuse your position for personal gain. Section 180, exercise care and diligence. The landmark case, Essex versus Adler, is strikingly similar, where a director diverted company funds to manipulate share for personal advantage. The court found multiple breaches. Applying this to Alicia is straightforward. Transferring 6 million from Cowbell to prop up Soya was a clear breach of Section 181, not in Cowbell's best interest. Using her position to achieve this was a breach of Section 182. And then loaning the remaining fund to her struggling business was reckless, violating Section 180. This is a textbook case of multiple breaches of fiduciary duty. The penalties are severe. Alicia could be disqualified as a director for years, face multi-million dollar fine, and even be personally liable to compensate Cowbell and its creditor. Essex, the corporate regulator, has the power to investigate, pursue civil penalties against her, and in serious cases, initiate criminal prosecution. The business judgment rule offer no protection here because Alicia acted with personal interest and against the company's best interest. So at the end, to summarize, in case one, the exclusion clause is invalid. So Jackson is entitled to succeed in negligence. In case two, Alicia has clearly breached multiple director duties, exposing herself to disqualification and heavy penalties. Thank you for listening.